Hello, everyone. Thank you for taking your time out of your busy days to join us here today for today's webinar regarding addressing disciplinary actions for federal employees. My name is Adam Grogan. I'm an attorney here at Tully Rinckey in our New York City office. I practice federal employment law as well as state and city employment law as well. I'm happy to be here with you today. Today, what we're going to go over, you're going to learn how to respond when you are under investigation for any alleged misconduct. I'm going to give a brief overview of your due process rights and what to expect from the agency proposing a disciplinary action, what your rights are when you receive a proposed disciplinary action, and how to reply to that proposal and what to include in your response. I'm also going to be differentiating between the proposed disciplinary action depending on your employment status and the length of the proposed adverse action, whether it is a suspension for 14 days or less, a suspension more than 14 days, a demotion in grade, or a removal from federal service entirely. I'm also going to be briefly discussing performance improvement plans and the importance of improving your performance during this period and how a federal agency might go about proposing removal for unsatisfactory performance after the completion of a performance improvement plan. And then I will be touching on the benefits of hiring an attorney during this process. I do want to note that today's presentation is going to be exclusive to federal executive agency employees. If you happen to be an employee of, say, the judiciary, your processes are going to be a little bit different. I encourage you to reach out and discuss any proposed or adverse action with one of our attorneys. So we're going to start with what to do when you are under investigation by your agency. It is important to note whether or not your participation in the investigation is voluntary or whether it is mandatory. If it is voluntary, the inquiry is most likely going to be criminal in nature, and you will have a Fifth Amendment right to remain silent to prevent yourself from incriminating yourself during any investigation. If your participation in the investigation is mandatory as a condition of continued employment with the agency, you have immunity from your responses being used in any subsequent criminal proceedings, provided that you answer truthfully. It is always important that when you're under investigation by a federal agency that you answer any question fully and accurately, because a proposed removal based on lack of candor can follow if you are less than truthful during these interview processes. You have the right to remain silent in the face of an agency investigation until the agency first provides you written notice of your rights. And that is whether you are being compelled to provide any testimony or any answers to the management questions that you are being posed, and that your answers cannot be used against you in any criminal prosecution. You'll be given possibly one of a number of different warnings. Calkine's warnings compels you to make statements or face disciplinary action up to and including dismissal, but it also provides you with criminal immunity for the statements that you are given. Contrary to that, a Garrity warning will advise you of the criminal and administrative liability for any statements that you may make, but it also advises you that you have the right to remain silent on any issues that would tend to implicate you in any criminal misconduct. It's a little bit less of a protection than Miranda rights, but Miranda rights could be issued subsequently to the investigation. If you do not answer truthfully, you may be prosecuted under 18 U.S.C. Section 1001 or for perjury. There are also different warnings that you may receive, such as Weingarten rights, which state that you have the right to have a union representative present during your investigation if you are represented by a union and if you so choose to have that representation with you. There are different types of disciplinary actions that you may face. You may face a letter of reprimand, which is a letter notice regarding misconduct or poor performance that remains in your personnel file. You may face a suspension where you will remain employed but are prohibited from working for a set amount of time and denied pay for that time period. You may be demoted and placed into a role at a lower grade with less pay, or you may be removed from federal service entirely, which is going to be similar to a termination. You have different due process rights when a federal agency is going to be proposing you for removal. There are a number of different statutes that authorize an agency to demote or remove an employee for performance-based actions. Chapter 43 adverse actions can only be used for failure in a critical performance element. Chapter 75 adverse actions can be used for performance or conduct that harms the efficiency of the service of that federal agency. There is a third one, Chapter 74 adverse actions, but those are exclusive to the Department of Veterans Affairs employees. And for the purposes of this webinar, we're going to be focusing on Chapter 43 and Chapter 75. If you are a Department of Veterans Affairs employee and you are facing discipline under Chapter 74, I recommend reaching out to counsel so that you can discuss your specific options moving forward with those allegations. For the more serious disciplinary proposals, the definition differs between employees in the competitive service and for the accepted service. Someone in the competitive service is generally considered an employee for due process purposes if they are not a probationary employee or have completed 1 year of, quote, current continuous service in the same or similar positions. It's defined as not having a break in federal civilian employment of more than a single workday. The 1 year provision does not apply to DoD employees, including in the departments of the Army, Navy, and Air Force, whose required probationary period in the competitive service is now 2 years. For those in the accepted service, an employee is someone who is not serving a probationary period or who has completed 2 years of current continuous service in the same or similar positions. A preference-eligible veteran in the accepted service need only have completed 1 year of current continuous service in order to be considered an employee for due process purposes. There are a number of differences between Chapter 43 and Chapter 75 performance-based actions. These are a few of them. For Chapter 43 removal actions or disciplinary actions in general, the agency must prove the performance is deficient in a critical element that you are being rated on. That is not the case for Chapter 75 removals or disciplinary actions, where they are not required to prove a performance deficiency in a critical element. For Chapter 43 removals, the agency is not required to prove that the removal would benefit the efficiency of the service, where they are required to prove that for purposes of Chapter 75 removals or disciplinary actions. And you will be, I believe that these slides will be provided at the end of the webinar today for you to peruse, and they're also available online at the Merit Systems Protection Board website. But a couple of important points to highlight. The deciding official who is going to decide the disciplinary action for purposes of Chapter 43 disciplinary action, it has to be a person that is higher in the chain of command than the person who has proposed the disciplinary action, but that is not the case for Chapter 75 disciplinary actions. Regardless of Chapter 43 or Chapter 75, the agency must provide notice of a proposed action and a reasonable opportunity to reply 30 days before any action can be taken. So you will be given notice of the proposed disciplinary action. You will be given a specific time period within which to respond, and a decision on that disciplinary action cannot occur within 30 days of the proposal. Another important point to highlight is that you have, for Chapter 75 actions, the agency must consider relevant mitigating factors known as the Douglas factors when reaching a decision on the appropriate penalty for the proposed disciplinary action and the charged conduct. However, for Chapter 43 actions, the Douglas factors are not used. So when you receive a proposed disciplinary action from the agency, there are a number of things that you are going to receive. You're going to receive written notice of the proposed action that is going to inform you the charges against you and the facts supporting those charges. And you will have the right to review the material or the evidence that the agency is relying upon in proposing the action against you. If you are not provided with an evidence file or the documents that the agency is using to support their charges and specifications for the proposed disciplinary action, that can be a due process violation on behalf of the agency. You are also going to be receiving, as I stated previously, a specific time period to respond to the charges. It is very important that you respond within that time period because failure to do so can be considered waiver of the ability to respond. The agency cannot impose a penalty more severe than the one that it proposed or based on conduct that is not contained in the proposed notice. However, the agency can rescind a proposed action at any time, but they can reissue the proposed discipline that could be more severe than the first proposal that was issued. For suspensions that are 14 days or less, an employee is going to be kept out of work for that time period, but these matters are not appealable to the Merit Systems Protection Board. However, you may have redress rights through, say, a union grievance or some other procedure that is usually going to be outlined to you in the decision to suspend you for 14 days or less. However, an employee who is proposed for suspension for 14 days or less is still entitled to advanced written notice stating the specific reasons for the proposed action, a reasonable time to answer orally and in writing, and to furnish affidavits or letters of support or other documentary evidence in support of that response. You're also entitled to representation of an attorney or other representative of your choosing. A written decision and the specific reasons for the decision at the earliest practicable date. Sometimes that is going to be right after that, the expiration of that 30-day notice period. Sometimes it takes a little bit longer. For discipline, including removal, suspension for more than 14 days, or reductions in grade or pay, an employee that falls into this category is entitled to at least 30 days advanced written notice unless there is a reasonable cause to believe the employee has committed a crime for which a sentence of imprisonment may be imposed. And that written notice is going to state the specific instances of unacceptable performance or unacceptable conduct by the employee on which the proposed action is going to be based. And for performance-based actions, it's going to state the critical elements of your position that are involved in each instance of unacceptable performance. You will be provided a reasonable time, no less than 7 days, to answer orally in writing and to furnish affidavits and documentary evidence that I previously described. Usually, we tend to see 14 to 15 days to respond to a notice of proposed discipline. And again, you have the ability to be represented by an attorney or another representative of your choosing. And you're still entitled to a written decision and the specific reasons for that decision at the earliest practicable date. In the case of a reduction in grade or a removal, the decision is going to specify the instances of unacceptable performance, and for unacceptable conduct, the written decision is going to state whether or not the allegations are going to be substantiated, not substantiated, or mitigated in some fashion. An employee against whom an action is taken for removal, suspension for more than 14 days, or reduction in grade or pay is going to be, under many circumstances, entitled to an appeal to the Merit Systems Protection Board. However, there are some exceptions that we will touch on in a little bit. So the format of the written reply to the agency's proposed disciplinary action The first thing that you're going to want to send out is known as an interim reply. That interim reply letter is going to include a request for information, including copies of the materials relied upon by the agency. You should have received this evidence file at the same time that you received the notice of proposed disciplinary action. However, there are instances where the information that the agency has used to propose the disciplinary action is, say, a video of some kind or an audio recording that can't be easily just presented in written format. But you will usually be given a contact person to reach out to in order to obtain that information. The interim reply letter is also going to request an extension, usually 15 calendar days upon receipt of the requested documents, and is also going to specifically state your desire to exercise your right to present an oral reply on top of the written reply that's going to be presented as well. The oral reply is a right, but it's an affirmative action that you must take to ensure that you receive one. It's not always granted as of right. And the interim reply is also going to put the agency on notice of a document hold for purposes of data preservation in the chance that the agency's decision on the proposed discipline is going to be appealed to the Merit Systems Protection Board. This puts the agency on notice that it has an obligation to preserve any emails, paper documents, videos, audio recordings, things of that nature, to not destroy that information as it may be necessary to be turned over during litigation in the future. And this interim reply is going to be served on the agency's deciding official with a carbon copy to the designated HR official, usually within 3 business days of receipt of the proposed adverse or disciplinary action. As far as the written reply itself, there are a number of things that you should include in your written reply. You want to highlight your employment background, how many years you've been with the federal government, any awards or commendations, time off awards, cash awards, on-the-spot awards, any kind of commendation that you've received from the agency, as well as a review of your performance evaluations. Up until the proposed discipline, have you always received, stellar yearly performance evaluations? You've always been, you've never received any discipline in the past, things like that. It's also going to state the specific charges against you and the specifications for those charges, and it's going to restate the agency's burden of proof in deciding the proposed the discipline to effectuate, if any, after the proposal. It's also going to include a legal argument, a discussion of the appropriate penalty for the charges and specifications, and any factors that should be considered in mitigation. And is also going to include oftentimes affirmative defenses. Do you believe that you are being disciplined or proposed for discipline because of a protected class, because of your race, sex, age, disability, things along those lines? Or are you being disciplined because of your engagement in the EEO process? Have you previously complained about discrimination or harassment in the workplace, and you feel that this disciplinary action is being taken in retaliation for participating in that protected conduct? It's going to include a sworn declaration from you, the employee, rebutting the factual allegations in the agency's proposal, and that's going to be separate and apart from the legal argument in the written reply document itself. As I stated previously, it's going to argue the mitigating factors, specifically the Douglas factors for Chapter 75 actions, which we will touch on in a little bit. It's going to assert affirmative defenses, and the reply must be sent to the agency's deciding official, which is usually designated on the proposal document within the time period that was prescribed in the proposal. I've mentioned a couple of times the 12 Douglas factors, which are going to be used to argue for mitigation of the proposal. Let's say they are proposing you for removal. However, you have a long and stellar record of federal service. You've never been disciplined before. This is the time to argue those factors for purposes of mitigating a proposal. The 12 Douglas factors are as listed in front of you: the nature and seriousness of the offense, your job level and your type of employment, whether you're a supervisor, whether you are a fiduciary. It's going to include your disciplinary history and your past work record. It's going to explain the effect of the offense upon your ability to perform at a satisfactory level in the future, and the effect upon your supervisor's confidence and your ability to perform your assigned duties. It's going to discuss the consistency of the penalty with those imposed among other employees for the same or similar offenses to ensure that you are not being proposed for removal, whereas a coworker who engaged in the same conduct was proposed for a 14-day suspension, something along those lines. It's also going to discuss the consistency of the proposed penalty within the agency's table of penalties. It's going to discuss the notoriety of the offense, whether it's been publicized, and whether it's had any impact upon the reputation of the agency, either locally or as a whole. It's going to discuss the clarity of the offense, meaning whether the employee was on notice of the rules that they allegedly violated. And it's going to discuss the employee's potential for rehabilitation. Is it going to is a lesser penalty than removal, say a letter of reprimand or a brief suspension? Is that going to allow you to rehabilitate your character in front of the agency and continue to work at the high level that they expect? It's going to discuss any mitigating circumstances, such as unusual job stressors, conflicts in the workplace, specific conflicts with a supervisor or the proposing official. And it's going to discuss the adequacy and effectiveness of alternative sanctions to deter any future such conduct by the employee specifically or others. As far as the oral reply to the proposed disciplinary action, it is a very important procedural right afforded to employees facing proposed adverse actions. The oral reply goes hand in hand with the written reply. This is an opportunity to speak directly to the deciding official with counsel present to present your response and your defense to the proposed action. The goal is to humanize the case for the agency deciding official so that it is not just a name on a piece of paper. The deciding official is going to have to essentially confront you head to head and listen to your account of events and listen to your response and get your perspective on the allegations, the charges, the specifications, the factual response to what has been submitted. You have the right to have an attorney present with you during the oral reply, and it can make a big difference. Your attorney can explain in a competent and formidable fashion any harmful procedural errors or affirmative defenses, and specifically break down to the deciding official what the agency has to prove in order to sustain the proposed discipline against you. And it is going to be an extensive legal argument that the agency may not be able to meet their burdens for whatever reason specific to the case. Eventually, after the proposal, after the written reply, and after the oral reply, you are going to receive a decision from the agency to either retain you, suspend you, reduce your grade, or remove you from federal service. This decision should be made within 30 days after the date of expiration of the notice period, but it cannot occur before 30 days have elapsed from receipt of the notice of proposed discipline. There are certain circumstances that would influence whether or not the agency is going to be able to provide a decision in a timely fashion. We generally like to get them back pretty quickly, but I have seen circumstances where the agency has taken a number of months to issue a decision following a written and oral reply on proposed discipline. Turning specifically to proposed disciplinary actions for unacceptable performance, you have to be given a performance improvement plan prior to the notice of proposed discipline. A performance improvement plan is a tool to give an employee with documented performance deficiencies the opportunity to succeed. It must be used to address alleged failures and meet specific job goals or to ameliorate behavior-related concerns. The performance improvement plan is crucial. You have to take it seriously if you find yourself in this situation. And if successfully completed, you cannot be demoted or removed unless your performance again becomes unacceptable within 1 year of completion of the performance improvement plan. The Merit Systems Protection Board refers to these cases as roller coaster cases, where an employee's performance is deemed unacceptable and then a performance improvement plan is issued. The performance improves to a marginal level and the performance improvement plan is considered successful. And then as soon as the performance improvement plan is completed, performance again drops to an unacceptable level. If the performance improvement plan is not successfully completed, if the performance is not raised up to that marginal level, your agency will most likely propose your removal or demotion for unacceptable performance. In the case of a reduction in grade or removal, it may be based only on those instances of unacceptable performance by the employee, and it has to occur within the 1 year period ending on the date of the notice in connection with the decision. As far as appeal rights to the Merit Systems Protection Board, the Merit Systems Protection Board is an independent, quasi-judicial federal administrative agency established under the Civil Service Reform Act of 1978. The board has both original and appellate jurisdiction over specific types of claims. An appeal must be filed within 30 calendar days from the effective date of the decision letter or the adverse action, and not all federal employees have appeal rights to the MSPB. Specifically excluded are political appointees, intelligence agency employees, general accounting office employees, and probationary employees, with those last three being only for certain actions. If you are an intelligence agency employee, a general accounting office employee, or a probationary employee, and you have received a decision on a notice of proposed discipline, I encourage you to reach out to counsel to discuss your specific appellate rights, if any exist. There are benefits to having an attorney if you are faced with a proposed disciplinary action. This is probably one of the most common questions that we receive during, or I guess following a notice of proposed discipline, is whether or not you need an attorney. But an attorney is going to be extremely beneficial to you for a number of reasons. First and foremost, you can be sure that the agency discussed with their own attorneys prior to issuing a notice of proposed discipline, and an agency attorney is likely to be involved in the process for the written and the oral replies and the decision-making process for the deciding official. It evens the playing field for you to have your own counsel who is going to be assisting you specifically. As specifically, an attorney is going to assist you in recognizing and preserving your claims. It's going to help you assert and develop evidence to defend any allegations against you. And it can develop any mixed case situations such as discrimination or whistleblower retaliation in conjunction with the notice of proposed discipline. There's also the ability for an attorney acting on your behalf to negotiate with the agency to settle the notice of proposed discipline in your best interest. Settlement negotiations are of critical importance, as the initial decisions on appeals often favor the agency. And it's also hiring an attorney is also going to ensure that your responses are timely. A missed deadline is the easiest way to get an appeal dismissed. It's also the easiest way to get an agency to disregard any kind of written reply that you submit if it's not submitted within the time frame that is designated in the notice of proposed discipline. The deadlines here are complex, especially when you get to the Merit Systems Protection Board. There's a lot of quick turnarounds in the process, and having an attorney on your side is going to help you navigate that very complex and very difficult field that you're going to find yourself in. And it's also going to help you utilize the Douglas factors to your favor. An experienced attorney can recognize any and all mitigating factors related to your case and ensure that they are properly asserted in your oral and written replies to preserve those issues should this case go on to appeal to the Merit Systems Protection Board. Some questions. That is the extent of the slides that we have prepared, but we've received some questions from the registration process, so I'm going to address some of those here. What are the client's rights during the pending investigation prior to the proposed action? So like I said, during the pending investigation, you will likely be read a number of rights, whether it be Garrity or Calkines, as I discussed at the beginning of our session today. And if you are a bargaining unit employee, you will likely be presented with Weingarten rights to have a union representative present during any kind of investigation. As far as the right to outside counsel, many agencies do not allow for attorneys to be present during a pending investigation or during questioning of an agency employee. However, it's generally a good idea to reach out to counsel and attempt to negotiate to have counsel present during those investigations. Should you always have representation when meeting with investigators? Absolutely. If the agency is going to allow you to have an attorney present, you should have representation present, because like I said, the federal agency has attorneys at their disposal. It only evens the playing field when you have someone in your corner advocating for you as well. Should you always expect an extension to be granted for a response to a proposed disciplinary action? No. You cannot bank on the fact that a requested extension is going to be granted. Many times we will issue an interim reply, and we will request an extension of the time period with which to respond. However, until we get an affirmative agreement that that deadline is extended, we operate within the original deadline. Even though we requested an extension, we have to operate as if no extension has been granted. When will you receive a decision to your written and oral response to a proposed removal? It could really be any time after the 30 days following the proposal has elapsed. If the written and the oral reply are submitted on the 30th day, it is possible to receive a decision on the proposal as soon as the 31st day. Oftentimes, however, there are delays with the deciding official and conversations between the deciding official and the agency's legal department that hold up a decision for an unfortunate period of time. So it's really when the agency gets around to it. However, if you have been proposed for disciplinary action and you have presented your oral and your written replies and you have not received a decision in an extended period of time, I encourage you to reach out to counsel and ask them to negotiate and intercede on your behalf. And can you remove a disciplinary note that is on your record? Sometimes. Sometimes as a part of a settlement negotiation between an attorney and the agency, you can come to an agreement to remove disciplinary notes or other negative information in a personnel file, but that has to come through discussions between you or your attorney and the agency. So I have one question here. Do all the procedures apply also to employees who are accepted service, federal employees, rather than general schedule designated employees? Whether the procedures are going to apply to your specific circumstance is going to be a fact-specific issue based on the classification of your employment and other factors. So if you fall outside of the general schedule designated employees, I encourage you to reach out to counsel to discuss your specific procedures and appellate rights. What is the time to retain an attorney during the investigation or after receiving the proposal? That's a good question. I recommend retaining an attorney, or at least speaking to an attorney, as soon as you believe that you are under investigation by your agency or immediately after receiving the notice of proposed discipline. because, like I said, the timelines are going to generally be very quick after you receive that notice of proposed discipline, and waiting until, say, the day before a written response is due is going to hamper any attorney's ability to adequately provide a response on your behalf. So as soon as you believe that you are the subject of an investigation or you are proposed for disciplinary action, I encourage you to reach out to an attorney as soon as possible. Can the agency move forward with a disciplinary action even if you have begun a rebuttal? Yes. So like I said, the specific time frame that is provided for you in the proposal document is going to be adhered to by the agency. If they have told you that you have 15 days from the date of receipt to respond to a proposed disciplinary action, that timeline is going to be adhered to unless you request an extension, and that extension is specifically granted by the agency. So even if, say, on the 15th day you're still working on a rebuttal, if you have not yet submitted it, they are able to move forward with that disciplinary action, even if you are in the midst of drafting a response. If you require more time, which oftentimes many people do, I encourage you to request an extension as soon as possible to give you as much time to negotiate that extension as you can. Is your firm available to represent you? Yes, absolutely. The last slide here is going to be my contact information. That is going to have my phone number, or I guess the office's phone number, and my email address. If you are the subject of an investigation, if you have received a notice of proposed discipline, I encourage you to give us a call, shoot me an email, and we will get you set up with a consult with one of our attorneys to discuss your particular circumstances so that we can provide the best possible defense for you. Is representation worthwhile in the case of a proposed removal for failure to fulfill the COVID vaccination requirement? It's complicated. I'm sure many of you are fully aware that the federal government's guidelines on vaccine requirements is ever changing, and it's very much up in the air. And oftentimes the different agencies can have different guidance out there. So if you have an issue with COVID vaccine requirements, I encourage you to speak to an attorney. How do you react if the agency is protecting a whistleblower that is making false accusations? So if the proposed discipline is based upon testimony that they've received from another employee, there is a specific analysis that has to be considered when taking one employee's statements against another employee's statement. It's known as Hillen analysis, and there are a number of factors that need to be considered when you get involved in proposed discipline that is essentially based on a he said, she said kind of situation. So if your proposed discipline is entirely based on statements that another employee has made, I recommend that you reach out to an attorney to discuss those specific circumstances. Do I have a right to know what the charges were before I was called in by investigators, and can a supervisor take immediate disciplinary action? So oftentimes when you are called in front of investigators, you're not always told exactly what the investigation is going to be about or what questions are going to be asked. Sometimes you will be provided that information, but not always. And can a supervisor take immediate disciplinary action? They are able to issue a letter of reprimand or something along those lines. However, for suspensions, disciplinary actions such as removals or demotions, it has to go through the proposal procedures and give you an opportunity to respond. Okay, Pat, I am going to turn it back over to you. But I want to thank everyone for being with us today. You asked some great questions. I'm sorry I'm not going to have time to get to all of them. However, like I said, if you have an issue with proposed discipline or investigation or any employment issue regarding you and your agency, I encourage you to reach out to an attorney. I'm obviously partial to one attorney in particular, but my contact information is on the screen for you. I encourage you to give us a call or shoot me an email, and we will do everything we can to assist.